afternoon. My name is Guillermo Patino, the chairperson designee of the New York City Loft Board. I welcome you to our November 21, 2024 public meeting. Section 282 of the New York State Multiple Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of inter-multiple dwelling units from commercial and manufacturing spaces to legal residential units that comply with minimum standards of safety and fire protection in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of legalization, and prosecutes parties who violate the law and the Loft Board's rules. Before we turn to vote on the minutes for several meetings, at the last meeting, the staff was asked to look into whether members could vote on meeting minutes for meetings which they did not attend. So I'll turn it over to our executive director to address that.
Yes, we reviewed Robert's rules, and a vote is required on the minutes. That was also another question that was asked, but it doesn't require that your attendance, that you be at the meeting to vote on the minutes. So therefore, to the extent you feel comfortable, you can vote on the minutes even though you did not attend that meeting.
Or were you even on the board?
Or were not even on the
Well, I mean, I would guess, since this has come up now the third time, and there's no way it can pass. You're lucky if we get 4 votes. However, I might agree that since we've all looked at these minutes a couple of times, maybe we should, and I'm not really quite, the Robert's rule is not terribly clear about this.
It doesn't say you can't.
Yeah.
It says they must be voted on.
Yes.
For them to be approved.
Yes.
But it didn't say anything about requiring
Yeah.
attendance.
And this happens to be a weird requirement of the city of New York. Whether there are 5 people here or 9 people here, we need still to have 5
Yes.
to make a majority. But I agree, we can't keep going on with this forever. So I'm prepared, since I read the minutes, and I missed 2 meetings, June and July, I'm prepared to now vote yes.
Thank you. We'll be voting on the April, June, July, and October meeting minutes. Separate? Yeah. Okay. So with that, we'll turn to a vote on the minutes from the April 18, 2024 public meeting. Is there a motion to accept the minutes? So moved. Thank you, Mr. Singletary. Is there a second? Thank you, Mr. Bowers. Mr. Rivera, can you please poll the board members?
Ms. Bresler-Whiskey?
Yes.
Mr. Bauer?
Yes.
Ms. Rogers?
Yes.
Ms. Piscopi?
Yes.
Mr. Delaney?
Yes.
Mr. Singletary?
Yes.
Ms. Rajan?
Yes.
Ms. Roseland?
Yes.
Chairperson Patino?
Yes.
9 in favor.
Thank you. We'll next turn to a vote on the minutes from the June 20, 2024 public meeting. Is there a motion to accept the minutes? So moved. Thank you, Mr. Singletary. Is there a second?
Second.
Thank you, Mr. John. Mr. Rivera, can you please poll the board members?
Ms. Bresler-Whiskey?
Yes.
Mr. Guerrero?
Yes.
Ms. Rogers?
Yes.
Ms. Piscopi?
Yes.
Mr. Delaney?
Yes.
Mr. Singletary?
Yes.
Ms. Rajan?
Yes.
Ms. Roseland?
Yes.
Chairperson Patino?
Yes.
9 in favor.
Thank you. We'll next turn to a vote on the meeting minutes from the July 18, 2024 public hearing. Is there a motion to accept the minutes? So moved. Thank you, Mrs. Singletary. Is there a second? Thank you, Ms. Rosalind. Mr. Mayor, can you please poll the board members?
Ms. Bresler-Whiskey?
Yes.
Mr. Bauer?
Yes.
Ms. Rogers?
Yes.
Ms. Piscopi?
Yes.
Mr. Delaney?
Yes.
Mr. Singletary?
Yes.
Ms. Rajan?
Yes.
Ms. Roseland?
Yes.
Chairperson Patino?
Yes.
9 in favor.
We'll next turn to a vote on the minutes from the October 17, 2024 public meeting. Is there a motion to accept the minutes?
So moved.
Thank you, Ms. Piscoping. Is there a second?
Second.
Thank you, Mr. Singletary. Ms. Rivera, can you please poll the board members?
Ms. Bresler-Whiskey?
Yes.
Mr. Bauer?
Yes.
Ms. Rogers?
Yes.
Ms. Piscopi?
Yes.
Mr. Delaney?
Yes.
Mr. Singletary?
Yes.
Ms. Rajan?
Yes.
Ms. Roseland?
Yes.
Chairperson Patino?
Yes. Next on the agenda is our staff reports, and we'll first turn to the report of our executive director.
Good afternoon. First, I want to provide you an update on the annual IMD registrations. We have 255 building owners that have renewed their annual registrations. We have 13 building owners that have sent in partial registration filings or have requested payment plans. We are working with these owners before enforcement begins. We have at this time 36 buildings that have delinquent registrations. 36 delinquent registrations. Second topic is fact sheets. Except for Mr. Delaney, I did not receive any other comments. His comment was a typo that has been corrected already. So the fact sheets for letters of no objection, sales of rights, and sales of improvements will be posted on our website. We are still working with the narrative statement fact sheet. Third topic is delivery of the materials for board meetings. Soon we will share the meeting materials via a OneDrive link. The department plans to stop using the share file system. The data security team at the department has asked that we restrict the ability to download the backup materials. You will be able to view them on the link, but you won't be able to download. While the staff tries their best to redact private information from the backup materials, we cannot guarantee that we will be perfect every time. So we're asking if there are any concerns or suggestions.
And this came down from the law department or?
No, this came down from the data security people at the department buildings.
Oh boy.
What we can certainly do is, in a separate email, I know a lot of you print out the orders. The orders are certainly do not contain any private information. I can email them to you so that you can print those, but the backup materials you will no longer be able to download them and print them.
What happens if we all pledge that we would download it and then destroy it?
I can take that back to them. I can take it back to them, and yes.
How do you like, how do you assess that you've done it? That's probably the thing.
I think the harder part is that you have to download it to see it on the computer because you guys would have the Wi-Fi. So if you have the Wi-Fi, we could read it while we're here in the computer, but if you don't have the Wi-Fi, you can ask those guys that if they don't have the Wi-Fi for us, then even while we're sitting in the meeting, there's no way we could see the materials.
So what should we all do, bring our computers in?
But
Yes.
so my point is that you can't bring in,
Well,
there's no point in bringing in the computers because they don't have a Wi-Fi.
But he's saying if we
they don't have a Wi-Fi,
Right.
right.
Yeah, we'll find out about the Wi-Fi capabilities as well.
But I'm not crystal clear on what the concern is here.
Data security.
Not that Elliot is going to sell the backup materials on eBay, but that hackers could obtain and read the 400 pages. I mean, it seems to me that
498.
I will frequently print out some pages of backup materials to make notes on or to refer to in the meeting. So it's not clear to me why all of a sudden this is an issue and whether the prevention measure is warranted under what we're expected to do our jobs. I mean, look at how deeply Ms. Roslin prowls the backup.
She doesn't print it, right, Ms. Roslin?
I do not print it. No, I don't print.
But you've downloaded the voice you
Correct, I download.
So what if we just said no?
The share file system is no longer available.
Right. And OneDrive, which I find to be not the most wonderful tool in the world, is the only alternative. And it's not that there's an increased distrust in Elliott, it's that the share file is more secure than OneDrive.
I don't know about this. That is,
Right?
You said that.
Well, that would not seem to support the argument that we shouldn't be able to download.
You know, every year when we fill out our year-end report, we have to make sure that the city that we're not doing anything outside of the law. Isn't that enough?
it's not that you're doing something wrong with the information. It's where the information goes after you download it, that's the problem. And some of it can contain private information. Even though we do our best to redact, bank accounts or security numbers, but I'm not gonna tell you that, we're going to be perfect every time.
You know, after 23 years, now the city decided to do this? It just doesn't make sense to me, sorry. Anyway.
I will go back to them and talk to them about another way we can do this, but I'm not optimistic, but I will talk to them to see maybe if certain files will be available for download and others. Maybe we can select them, although I'm not sure that's going to be helpful to you, because you may want to print the very ones that we select have private information.
Possible.
Yeah.
Particularly when I see a particularly egregious stipulation that strikes me as way outside the realm of what would make sense to me. But also I would think that we should be able to download and print proposed orders and reports and recommendations.
Certainly, I can email that to you.
So, let me ask you a question. So, how do we do with this?
Yours, yours.
Huh? What does the city want us to do with this after you print this out for us?
Well, that's public information, right? The proposed order is on our website. It's the backup materials that may contain
As
people's
Kirk said,
address.
Sometimes it's
Social security
360 pages of backup.
But, this coverage case is a good example. We have people's driver's license, bank account information, credit card information. All of that information is part of this backup and is routinely part of the coverage case. So these are all things that we should be concerned about. So the city, Department of Buildings has said to me that we'll be able to view it in that time. I will ask them to see if there's something that we can, perhaps we can select certain files that you could download, like the application, the answers, any settlement agreements, all of that should explore the information. So.
When this goes into the oath court, that's public, right?
We are, in FOIL, we do not release any document, or we redact any document that has private information. Someone's social security number, someone's banking information, someone's credit card information. So all of that is redacted.
And I've never seen it accidentally missed, not that I've looked at every single page of backup information, but when we look at residential proofs and stuff, invariably, generally, the applicant has redacted that information before submitting it to us.
Certainly, if they haven't, we do.
Right.
But certainly, it's possible that they'll miss it and we'll miss it.
Also possible all the molecules in this room could end up in one corner and we could all suffocate, but it doesn't happen that way.
I agree.
So what about the Wi-Fi issue?
I'm going to ask about it, okay, to see if we can get access to the Wi-Fi in this building.
Because otherwise you'll be in a position that none of us can read anything
Right,
while we're sitting.
yes. But what I do is I wouldn't be able to download it, yes, I was going to. Yes. There was that idea, yes, okay. All right, I will talk to them, and I will report back.
But from my vantage point, simply having Wi-Fi in the room is not an adequate solution in and of itself. If I want to make notes on an order or mark a typo,
Yeah. Well, Chuck,
Orders are not, that information.
Are not
that
the
can-
concern.
I will forward that. That's certainly not heavy enough that I can send to you via an email. And you'll be able to download and save it to your computer.
Chuck and I remember that early on, all of this stuff used to be delivered to us.
Remember?
They would ring the bell.
A big
right,
binder.
And a big, Oh.
Yeah, instead of the copier for days copying all that stuff. I'm glad we don't live in those days anymore. Okay. Anything else you want to say with regard to this? Okay. The last thing I wanted to say is regarding personnel, we are very close to hiring a legalization attorney. So that will come as a great relief when that day comes. Any other questions or concerns for me?
I think I might have a question on the
can we talk about this?
Yeah, that's part of the role discussion.
In the minutes, when discussing the housing maintenance code, on page 7 of the minutes, you stated that you'll remove language about the notice. The staff will create a second version with immediate notice and removal. I didn't see a second version in the materials we received.
The version that I sent you is a second version.
Oh, I see. Not an alternative.
Right, exactly.
Got it, okay. Okay.
Thank you. Next we'll have Ms. Story, who will present updates on legalization and enforcement.
Thank you, Chairperson Patino. For enforcement, we did consult about possible litigation concerning one of our buildings. With regards to legalization, and the narrow statement conferences, we have conducted about 9 narrow statement conferences between now and the last board meeting. 4 legalization conferences, and we have 14 narrow statement conferences scheduled so far between November and December. And we even have some in January, but I haven't placed that one yet. Any questions?
Could you elaborate a little bit on the consultation about possible litigation?
I knew you were going to ask them.
I think we need to go into executive session.
Well, given that enforcement is an issue near and dear to my heart, I would support going into executive session too.
Can we do it at the end?
Pardon?
Can we do it at the end?
Sure.
Great.
And secondly, can you remind me of the difference between a narrative statement conference and a legalization conference?
And I knew you was going to ask that too.
Good.
So the narrow statement conference is usually between the owners and the tenants. It gives them, opportunity to discuss the proposed work. Usually the legalization conferences we have are just probably professionals discussions because they have some sort of disagreement and it makes no sense for us to bring the tenants in on that. Sometimes it can be trying to settle something that really is not necessarily what we would do, but we're trying to do that to help move the process along before the parties file actions, because it's going to take long, and then that means that the tenants may not get something, and that means there's going to be more money on both sides. And other conferences in the legalization thing can mean something concerning housing maintenance. So there's some sort of housing maintenance issue that's not being addressed, and one party is saying, no, usually the tenants, no, we need to have a conference and understand what's going on here. and we help them to set up access dates and make sure that those things are being settled. If not, then that will be a precursor to enforcement. So we're trying to like mitigate the issues before it even gets that far, so that the tenants can get what they need more immediate rather than going through the enforcement time frame, which can take a while.
And with narrative statement conferences, both sides are noticed about the conference. Is that the case in legalization conferences as well?
So yes, both the tenants professionals and the owners professionals are noticed. We don't have conversations out, without both, because we need both to come to some sort of agreement.
Right. And do tenants and owners sometimes attend those?
So if it's like a legalization conference, it depends on what type it is, but if it's like a professionals only, that means we're only asking for the professionals, so both sides to come in and discuss it. But if it's sometimes like housing and maintenance issues, sometimes the tenants will come and sometimes the owner will come, and then you can hear a lot of disputes there, like some sort of miscommunication. Oh, I sent this in, and the owner's saying I didn't get it, and it's going back, but I know it now, let's set up some access days so we can do that.
Okay.
So the professionals are generally the attorneys?
Lawyers and architects.
And the engineers and architects?
Yes, ma'am. Any other questions?
Thank you, Ms. Doran. We'll now turn to a discussion on the proposed amendments to Title 29 of the Rules of the City of New York, Sections 204, 205, and 211.1. Stefania Ruiz will briefly describe her findings in her research of the Building Code and Fire Code, and then we'll turn it over to Ms. Cruz, who will explain the changes that have been made to the rules since we last met.
Hi everyone. First of all, sorry for last month. I speak really fast. I'm going to try to slow it down and just speak really fast here. Are you listening to me now? Okay. Now you're listening, but I think you hear me, right? Yeah. Okay, so I've been researching this issue for the last month, and it was really interesting. And we have found that the owner has the duty and obligation to maintain in good repair and maintain the common areas, including the egress, to conform with regulations. We also find that this duty is non-delegable duty, and that the tenant has the obligation to follow those rules. I looked through 4 regulations where we find the authority to this duty of the owner. So the first one is under the Housing Maintenance Code, the Section 27-2005. The owner of the multiple dwelling shall keep the premises in good repair. The owner, in addition, shall be responsible for the compliance with these requirements of the code. The second regulation is under the New York City Fire Code, Section 1027, maintenance of the means of egress. Under this section, the means of egress for buildings, structures, or premises shall be maintained in accordance with the construction codes, including the buildings codes in these sections. This code also states that it shall be unlawful to obstruct or impede access to any required means of egress, including any exit or exit discharge. You can see more details of this code in sections 1027.1, .2, and .4.5. The third regulation that I was looking for, it was the New York State Multiple Dwelling Law, Section 78, where it says that the owners of the multiple dwelling are responsible for keeping the building in good repair, including common areas and of course including egress pathways. And lastly, the fourth regulation is the same regulation, but the Section 53, the fire escape maintenance. You can find the 53 Section A, B, that the owners must keep and maintain all fire escapes in good conditions and repair, And the section 53AC makes this a criminal violation punishable as misdemeanor under NDL 304. This suggests that the owner should not resort to self-help in these situations. The law implies that the owner should seek civil or criminal remedies to address these violations. I found.
Okay, going through the changes. First, I owe you all an apology. On page 7, at last month's board meeting, we were talking about the fines that could be levied for failure to register. And the version of the rule that I gave you is not the correct version. The story is correct. The fines for failure to register, and we're talking about the correct amounts, are on page 7 now. So that chart where it says fine failure to timely renew registration, those are the correct amounts. That's the chart that should have been in. I grabbed the pre-2023 chart instead of the most current chart. So the amount for, we talked about it being consistent between the failure to register and failure to comply. So I changed that penalty to $7,000. On page 2, there was conversation or discussion about adding a definition to the means of egress. I'm working off of the version with the track changes, so you can identify quickly.
Is the printout in front of us and the one that was emailed to us the same?
Yes. So the version of the track changes is on page 2. I've added the definition of means of egress. On page 3, near the top, capital A, I've added language that says that fire escapes must be maintained free from obstructions for immediate use in the event of a fire or other emergency. On page 4, short talk discussion last month, we agreed that if the housing maintenance code, the MDL, or the fire code did not include the notice provisions that we have been discussing, that we would remove those very same notice provisions from this rule. I've done that. As noted by Ms. Ruiz, this version still includes the requirement that the owner remove the personal items, personal belongings from the hallways, from the stairwells, from the fire escapes immediately. That if that part of the requirement was not found in the fire code, building code, or the housing maintenance
What this doesn't have any indication of stay, what happens is when a package is delivered, does that package not stay in the lobby of the building since you can't be there? So what happens with the packages that are delivered to these various buildings? They have to be put somewhere. And are they stored or just delivered? Maybe the language is not specific about it.
I don't think this rule is geared toward a package that is delivered and it could be in the hallway for a few hours while someone gets home, right? I think this rule is geared toward the storage of personal items in the common areas and in the stairwells and on the fire escapes. I think that's what that's the target of this rule, right? Is to keep shoes, strollers, anything that could prevent a stretcher or
No.
trip a first responder in a smoky situation, you want to eliminate all of that, and that's what this rule is for. Certainly, a fire could happen at any point, a package could be delivered, and the fire could start, but I don't think that that is what this rule is geared toward, right? This rule is not geared toward things that will be removed from the egress in a few hours. We're talking about, things that are stored in places where they should not be stored. Packages in most of the buildings that I've been in are stored or are left in the lobby. I've seen also where there is a room, like a mail room, that's not immediately when you come in, but sort of off to the side. The mailboxes are there, and there's sometimes a table where packages are left for the residents. That's what I've seen.
Well, I totally agree. If that is clear for all of the owners and tenants, then that's fine. But we don't say anything about it.
I think,
Okay.
I gave you today, I gave you this, which is what we drafted, the notice that will be put into the common areas to notify everyone. It'll be a requirement that this be posted, just like the loft board notice and the loft board sign. It should be, the idea is that it should be right next to it, so that the tenants are aware that there should be no personal items outside of their apartment, even at their door, shoes, baby strollers, anything of the like that could be a potential trip hazard in an emergency. So I'm open to ideas. I'm not wedded to any of this language. Just wanted to show it to you. If you have ideas, you can email me or tell me now, and we'll circle back on
All right, and this should be posted in the buildings?
it. In the lobby, yes.
In the lobbies, yeah.
The idea is that this notice will go right next to the loft board notice in the lobby or near the mailboxes or anywhere where the tenants have access. It could be on every floor. I mean, at minimum, it should be in every lobby.
Is there a penalty for not posting?
We didn't add it, we will add it. I'm sorry? I don't think there is, so we will add that. Thank you. I'll check the file code.
For the existing loft board notice, is there already a penalty?
Oh, yes.
Yeah.
Yes.
To make
It'll be. I don't know, we don't know, 2,000, but it'll be the same. Yeah, it'll be the same.
You want to do the same?
Yeah.
Does FDNY have a position on this?
So I brought my fire code with me in the 2022 New York City Fire Code, section 1027.4.5, personal property. Bicycles, baby strollers, clothing, and other items of personal property, excluding those set forth in the Fire Code 1027.4.1 through 1027.4.4, shall not be stored in the building hallway corridors except as may be authorized or allowed by the department. 1027.4.1 is incidental furnishings. A building hallway corridor or elevator lobby may be furnished with a console table, console bench, mirror, and umbrella stand provided that the minimum required egress width is maintained. All such furnishings must be incidental to hallway use and that the purpose of such furnishings is primarily decorative and/or for the convenience of persons passing through the hallways. Incidental furnishings shall not include furniture used to hold or store clothing or other combustible items, or storage in the hallway of furniture such as beds and dining room tables whose primary purpose is not decorative or for the temporary accommodation of passers-by.
This is, I don't want to make a big fuss about this, But I understood that this was the rules of the city of New York before we got into this. And the fire department is even more explicit about it than we are. I thought that's terrific what you just read. But anyway,
So this can be found online, so everybody's, capable of reading this if they're interested, chapter 10.
This proposed rule gives us the authority to impose fines. That's the theory. I was recently, after our board meeting in October, I went to a building. The fire escape at this building was the worst I've ever seen. And I walked away with, we have to do this rule, because I would have been able to go back to the office and issue a violation immediately. What I had to do was go back and make several phone calls to the department to have an inspector go out there and do what we should have every authority to do.
Well, 1027.7 has a fire escapes clause. Fire escapes and access thereto shall be maintained in a safe and operational condition and continuously maintained free from obstructions and impediments to immediate use in the event of a fire or other emergency.
you know, one of your colleagues that was here at one point said to us, we don't use the fire escape because we're not convinced that they're safe and that you use ladders to get up into the building. So, so fine, make them all safe, obviously.
Well, they're supposed to be kept in good condition.
Absolutely.
I have two small comments.
Okay.
And one is, just in terms of, so that something that's defined within the definitions is then capitalized within the language of the text. And there's a little back and forth. Sometimes things are and sometimes they're not, like fire escape order, things like that.
Okay.
Right, so just I don't know if that's a legal thing that if it
It should be
refers to something
consistent.
that, right, okay. And then on page 3, section 2, section 11, little I, capital K. It says the egress by a fire ladder must lead into a court or yard with an unobstructed pathway to the street. Should that be fire escape? Because not all fire escapes lead to the ground with a fire ladder. You could have a stair that goes all the way down, you could have, right, there are others. So it's the fire escape needs to go to somewhere on the ground that then leads to the street. And by you saying fire ladder, you're restricted. It doesn't matter what the bottom of the fire escape is, right?
Yes, you're right. So my question is also, are we keeping the requirement that the owner must immediately remove the item?
To me, it seems that in everything that you were sharing in research, the owner is responsible for maintaining egress. So I would assume that means that they would need to remove items like that to uphold their obligation to maintain egress.
And even the fire code, so it's implied.
Right.
It's implied in all the codes that you can't have anything in any of the means of egress, the borders, the stairs, the fire escapes, however you want to define that. It is not explicitly stated that it is whose responsibility it is to remove that. In the way these rules, this draft of the rules is currently written, it explicitly states that the owner is responsible, and if the owner does not fulfill that responsibility, there's a penalty. So, do you need the language that explicitly assigns responsibility in order to assign penalty?
No.
So it's in there whether we say it or whether it's explicit or not.
I agree.
Do you have a preference from the legal standpoint of whether or not it's included?
I think I'd rather be consistent with the other governing law.
So not included?
Not included.
Yeah.
Are you striking it?
Yes.
What exactly is being stricken? On what page?
Page 4.
Page 4, subparagraph C.
Yes. Capital C?
Yeah.
Yes. Yes.
What the immediate?
Yes.
So we're taking out that entire paragraph.
And that would imply we
C
take
and-
out D also.
Yes.
And we all agree that the items could be stored in the basement, even though we don't say that.
Yes. It's an owner's trust.
Okay, so under little 3, we'll only have A, B, and what's currently E will become C, correct?
Yes.
A on, in that same section, storage of items in a corridor used for egress is prohibited. The track changes states we're deleting a corridor used for,
Yeah, I saw that too.
but we're not.
Yes. I deleted it word again.
Well, shouldn't corridor be changed to means of egress if this whole section is about means of egress?
The other thing I'd like to add, and of course it doesn't make much sense, but many buildings don't have an elevator. And if there's an elevator in the building, you're not supposed to use it in case of fire. In which case, anything could be stored in the elevator. Is that correct?
You said the elevator?
Yeah.
Well, I mean, in case of fire, you can't use the elevator. You have to use either the fire escape or the stairs. So, in other words, you can store anything in the elevator, and that's perfectly okay.
for storage is
Okay.
not,
I mean, all I'm saying is that it's not specific enough.
you don't think corridor means
And it's not that
egress?
I'm willing to kind of rewrite it in some way to make it more specific, but that's all I'm saying.
Yeah, exactly. We can always amend the rule.
I mean, the owners and the people that either rent or live there really should have a full idea of what is okay and what isn't okay.
I think you're overthinking this one, Alex. If I leave my bicycle in the elevator, I'm an idiot. Right?
All right, I've got to shut up.
Are we in a position that we could actually vote to adopt this today?
Yes, we would have to amend, include in the description that we're amending it to include a fine for the posting of this notice, and set the amount.
You mean the not posting? the village
Yes, I'm sorry,
posting.
we're not posting, yes, thank you.
Any other teaching?
Any other changes we discussed, yes.
Should
Happy to offer
probably
that
try to
motion.
vote on this because otherwise we have to wait until January.
This gives me the ability at least to go back to law, to find out whether we can get certification. There are a lot of changes to this rule, so.
All right, so can we just go over the changes for everyone's edification, to make sure we're all on the same page?
Have consistent use of capitalization throughout, so that could be double checked. Have added fine for failure to post a required notice. I will propose 1,000 to be consistent with the failure to post the IND notice. And then I have removed C and D under personal property stored in the means of egress section. In that same section, personal property stored in the means of egress, item A, we want to rewrite that item to read storage of items in the means of egress is prohibited. There was one more that you have, Ms. Rossman.
On K, of the section 2, capital K, on page,
Fire escape.
yeah. Replace fire ladder with fire escape.
Those were all the changes I noted. Any additional? Does somebody want to make a motion to vote this out? All right, I'll have Ms. Pisco Pink and then Mr. Singletary. Mr. Bear, can you please pull the board members?
Ms. Prestonowitz,
Yes,
Mr. Barber,
Yes,
Ms. Rogers,
Yes.
Ms. Piscopin,
Yes.
Mr. Delaney,
Yes.
Mr. Singletary,
Yes.
Ms. Barjon,
Yes.
Ms. Wilson,
Yes.
Chair Pepino.
Yes. Thank you. And just to clarify, that was a motion to move forward with the proposed amendments to Title 29 of the Rules of the City of New York, Sections 204, 205, and 211.1, with the amendments that the board discussed today. And just to reiterate those amendments, it's ensuring that there's consistent use of capitalization throughout the proposed rule, adding a fine for failure to post a required notice being proposed in this rule. That fine would be $1,000 to be consistent with the failure to post IND notice fine and the penalty schedule today. Removing items C and D under personal property stored in the means of egress section. In that same section, personal property stored in the means of egress, we're rewriting item A to read storage of items in the means of egress is prohibited. And then in section little I, fire escapes, item K, we're rewriting that item to read the egress by a fire escape must lead into a court or a yard with an unobstructed pathway to the street. Thank you. So next, we'll turn to our case agenda.
So just before we leave this, the next step is it goes back
Too low.
to law. And if law
says everything's great, what happens then?
It goes to the city record for publication.
It goes to, okay, so it doesn't have to come back to us.
No.
Good.
Okay. Okay. No, that's fine.
So next is our case agenda. There's one case on the summary calendar. The case is 57 Dame Street in Brooklyn, docket number LS0308. Are there any comments on this case?
My comment is I'm going to abstain because I recall having some kind of conversation with one of the tenants, Kevin Lindemer,
Okay,
and I don't recall the subject matter of that conversation, but I'm going to abstain.
okay, thank you. Is there a motion to accept this case? Thank you, Mr. Barowitz. Is there a second? Thank you, Mr. Singletary. Mr. Rivera, can you please pull the board members?
Ms. Representative Lewinsky?
Abstain.
Mr. Barber?
Yes.
Ms. Rogers?
Yes.
Ms. Cooking? Yes. Mr. Delaney?
Yes?
Mr. Singletary?
Yes.
Ms. Vardan?
Yes.
Ms. Ralston?
Yes.
Chair Patino?
Yes,
8 in favor, 1 abstain.
thank you. We'll now turn to vote on the cases on the master calendar. The first case is 325 Canal Street in New York, docket number TR 1400. Ms. Oyegwe will present this case.
Good afternoon. Thank you, Chairperson Patino. The applicant in this case applied for Article 7C coverage pursuant to MDL Section 2815. In its answer, owner argued that the building was not eligible for coverage because it was removed from the Loft Board jurisdiction following declaration of intent filed by prior owner of the building to return the building to commercial use. Owner also contended that tenant's unit was deregulated due to sales of right pursuant to MDL sections 286.6 and 286.12. The initial question in this case is whether coverage pursuant to MDL 2815 is barred by the building prior owner, prior coverage under MDL section 281.1, which ended with says pursuant to MDL sections 286.6 and section 286.12, and revision to commercial use pursuant to sections 2-10D1 of the Loft Board rules. There is nothing in the plain meaning of the statutory language that supports that coverage is based upon prior Article 7C coverage or priorities pursuant to MDL sections 286.6 and 286.12. If the legislators intended that coverage is contingent upon the absence of prior coverage, the legislator could have included such language in the MDL section 281, excuse me. The next question is whether the building meets eligibility criteria for Article 7C coverage. MDL 2815 sets out the eligibility criteria for Article 7C coverage. In particular, the statutes provide that the building must lack a residential certificate of occupancy and must also have been occupied for residential purpose by 3 or more families living independently from one another for 12 consecutive months, between the period of January 1st, 2008 through December 1st, 2009. In addition, the unit seeking coverage must not be located in the cellar and must measure more than 400 square feet. In support of the coverage claim, tenant testified on his behalf and presented testimony of a prior tenant of the 3rd floor in the building. Based on testimony and documentary evidence presented, the building lacks a residential certificate of occupancy and it was occupied for residential purpose by 3 families living independently from one another for 12 consecutive months. Tenant testified that the unit is not located in the cellar and it measures more than 400 square feet. The preponderance of evidence in records established that the building and the tenant unit meets the eligibility criteria for Article 7C coverage. The proposed order grants the application for Article 7C coverage under NDL 281-5. Is there any question? Thank you.
Thank you. Are there any comments on this case? Is there a motion to accept this case as amended to add a sentence that reads, on June 2, 2007, tenant signed a lease for a second floor unit in section 2 of the proposed order before the last sentence in that section, and then also to fix a typo in the first paragraph of page 3, second sentence, it'll read, in 1982, the legislature enacted Article 7C and established, instead of established, the statutory criteria for coverage in MDL section 281-1. Ms. Rosalind, is there a second? Thank you, Mr. Singletary. Mr. Rivera, can you please pull the board members?
Ms. Preston-Norsky?
Yes.
Mr. Barber?
Yes.
Ms. Rogers?
Yes.
Ms. Pinko-Pink?
Abstain.
Mr. Delaney?
Yes.
Mr. Singletary?
Yes.
Ms. Rajan?
Yes.
Ms. Rosen?
Yes.
Chairperson Patino?
Yes. Thank you.
8 in favor, 1 abstain.
Thank you. The next case on the master calendar is 792 Flushing Avenue in Brooklyn. Docket numbers RA0016, RG0217, and LE0757. Are there any comments on this case? Is there a motion to accept this case? Thank you, Mr. Delaney. Is there a second? Thank you, Ms. Rajan. Mr. Rivera, can you please pull the board members?
Ms. Preston-Norsky?
Yes.
Mr. Barber?
Yes.
Ms. Rogers?
Yes.
Ms. Pinko-Pink?
Yes.
Mr. Delaney?
Yes.
Mr. Singletary?
Yes.
Ms. Rajan?
Yes.
Ms. Rosen?
Yes.
Chairperson Patino?
Yes. Thank you. That was the last case on the agenda for today. We have a motion to move into executive session to discuss potential litigation. Thank you, Mr. Delaney. Can I get a second?
Second.
Thank you, Ms. Biscoe. Mr. Rivera, can you please pull the board members?
Ms. Preston-Norsky?
Yes.
Mr. Barber?
Yes.
Ms. Rogers?
Yes.
Ms. Pinko-Pink?
Yes.
Mr. Delaney?
Yes.
Mr. Singletary?
Yes.
Ms. Rajan?
Yes.
Ms. Rosen?
Yes.
Chairperson Patino?
Yes.
9 in favor.
Motion to go back into public session. Thank you, Mr. Delaney. Can I get a second?
Second.
Thank you, Ms. Biscoe. Mr. Rivera, can you please pull the board members?
Ms. Preston-Norsky?
Yes.
Mr. Barber?
Yes.
Ms. Rogers?
Yes.
Ms. Piscoping?
Yes.
Mr. Delaney?
Yes.
Ms. Rajan?
Yes.
Ms. Rosen?
Yes.
Chairperson Patino?
Yes.
8 in favor, 1 absent.
Thank you. This will conclude our November 21, 2024 public meeting. Our next public meeting will be on January 16, 2025. Thank you.